invented my Roman coin. I did two things. I wrote a book while I was in there, and invented these Roman coins. They're based on the book of Romans, primarily chapter 5, but really 3 through 8. If you want to check them out, they're $10 or $15 each, whatever you can contribute. They're very nice coin. They have concepts on one side and the exact opposite on the other side. So even if you're not a believer, not a religious person, you can gauge every decision you make, every action you take, by which side of the coin it's on. And it's pretty cool to watch what kind of an asshole you really are. I do it all the time. Okay. We're in court now. The opening statements have been made. Bill's been sworn in. So now, remember, he's under oath. He can't lie. He's also an expert witness. So his words have validity in the court, but there's also documentation. And that documentation's all been brought in. It's been entered into evidence. It's all listed as exhibits and blah, blah, blah. So the process, pretty simple. Depending on your judge, the judge can ask the jury if they have any questions. Now, normally, if the judge is really concerned about what's going on, after the plaintiff talks to his witness, because he's my witness, I'm the plaintiff, I brought him in, he's considered my witness. After I talk to him, judge is going to ask the jury if they have questions. Then I'll sit down, he'll ask them if they have any questions. They can bring up very simple, quick questions. Then the defense takes over. After the defense is done, they ask the jury again if they have questions. Not all judges are going to do that. They are allowed to do that, and they should do that. The jury can only decide on what they understand. And they can actually interrupt. You will never see it in court, but they can interrupt. If they don't understand something, they can raise their hand. They can get the judge's attention. They do have that authority. You just don't see it very often. And if a juror does it too much, they'll probably get removed. Okay? If you're ever on a jury, you do have certain authorities to ask questions so that you don't get the wrong idea of what's going on. Okay. Mr. McCaffrey, can I call you Bill? Would that be okay?
Sure, Bill's fine.
All right, Bill. Can you give me a quick synopsis of your background?
Yes, I've been in the banking business for 31 years. Started out in banking roughly the age of 18. At that point in time, I've had numerous dealings with not only the reconstruction of loans, but securitization process, most importantly the securitization process, and other matters that would relate to banking would be as far as finding out who in fact is the true party in a lot of these foreclosure cases.
Okay, so is there really any aspect of a mortgage, deed of trust, the transaction, the securitization that you're not familiar with?
No, I used to handle between $5 and $8 billion a month, and so I'm very familiar with putting not only private label securities together, but also public label securities. Public labels meaning selling them to Lehman Brothers, and private labels from the institution that I was with for 12 and a half years would be private label securities.
Okay, did you have an occasion to peruse all of the documents concerned in this matter?
Yes, I have. The documents that I have in front of me, I've examined, and prior to that, I examined the note in the attorney's office, and There seems to be some very, very, very disturbing things with these documents,
Okay. Well,
in
then
my opinion.
I turn your attention to Exhibit A, the promissory note, and simultaneously Exhibit B, the deed of trust. Did you discover any evidence that those are the same document?
Well, the first thing that I noticed that's rather troubling is that it looks like this note has been copied. It is not stamped true, certified, correct, exact, so I can't ultimately tell you. But the note that I examined in the attorney's office was a copy that, again, was not stamped true, original, correct document from the person who had the note. So I cannot attest to the fact, the validity of this document, but it does look like it came from, with the holes punched in. It looks like it's been imaged and copied and pulled out of a file, but I haven't seen anything that would relate to the fact that it's a true, original, exact, correct copy.
Okay, the evidence of its originality or authenticity notwithstanding, did you discover any evidence of the promissory note in question and the deed of trust being one congruent or
Objection.
one document?
Objection, Your Honor, that's leading.
Sustained. Continue.
Yeah. You better let me answer that question.
Is there any evidence that you were able to discover that would make this court believe, or a reasonable man believe, that that is one document?
No, it appears to be that this document was procured by a company called Homecomings Financial Network Incorporated, who then made that document and then assigned that document to an individual who is unknown at this point in time, but after later discovery, found out who the original document should have been assigned to, but there is no assignments that follow the deed of trust.
So is it therefore then your expert opinion that the deed of trust and the promissory note are two completely separate documents?
It is. It's a terminology that we use in the banking business called bifurcation. This note did not follow the deed of trust.
Did you discover any evidence of where the deed of trust was sent?
Well, the deed of trust is recorded in the county recorder's office.
Did you then discover any evidence of where the promissory note was sent?
No. I did receive, again, a copy of a note I reviewed, but the assignment that is stamped on the back of it is merely taking it away from the originating entity, which is Homecoming Financial Network. It's a Delaware corporation, and it looks to be stamped, and I can't tell whether or not it's a stamp, but it should have a wet signature on there.
Then I turn your attention to the note itself, or the unauthenticated copy of the note. How many different aspects of modification and or alteration do you find in the promissory note?
Well, the biggest problem that we find in the promissory notes are the fact that it's generally stamped, and it has to follow the deed of trust. And when they're not stamped properly, then a chain of title is broken.
Okay, are there holes in the note?
There appears to be holes in this note, like I pointed out earlier, that looks like it came from a folder, but any alteration of any note that has holes punched into it, any strikes or whiteout or anything that would have any alterations whatsoever, this note would become null and void.
So is it therefore then your contention pursuant to the Uniform Commercial Code it was accepted in totality in the state of Arizona, that the obligation of the obligor was discharged by the defendant and/or one of the defendant's allegiances.
Objection, Your Honor, that calls for a legal conclusion.
Your Honor, he's pretty much here to make legal conclusions, so we'll just let him do it.
Okay.
I'm going to overrule, and I would appreciate if you'd rephrase the question.
Is it your expert opinion that due to the fact the defendant and/or one of the defendant's allegiances knowingly, intelligently, and willfully, with full knowledge of the consequences thereof, purposely altered and/or modified the note to therefore discharge the obligation of the obligor?
I believe it would be in the best interest of the person who is actually holding the original note not to alter any of these documents in any way, shape, or form. But again, when you do not have a true certified correct copy, or you don't have the ability to review the original document, the document is always going to be in question, in my mind.
Your Honor, I take leave with the court to allow us, just in this circumstance, if the defendants concur, that we consider this for this matter right now that we're discussing as if that is the original note. Does defense concur?
We don't concur on that, Your Honor.
Then if they don't concur, Your Honor, can you please arrest them for putting the false document in the court?
I would recommend that you get an original, if possible, into this court.
Your Honor, we don't know where the original is, actually.
Your Honor, just for this instant, can we just concur that we're going to act for the courts, just to save the court's time, that we'll act as though this is original?
Ms. Quintel, do you concur?
With caution, I'll
Okay,
concur.
we'll proceed.
Okay,
We'll
so
accept that.
back to the issue at hand, Bill. We're just going to act as though this is the original. Like, let's say they actually brought the original in. If this was the original and it had holes in it and it's been stamped, paid to the order of with some kind of endorsement, whether it be blank or not, and without recourse, would you then therefore state for the record that that has discharged the obligation of the obligor?
Well, if there's any alterations and there's holes in this note, being the original note, this would be an invalid instrument, along with the fact that if this is the stamp, and I'm going to, for these purposes, say that there is a wet signature. It looks like the Homecomings Financial has stamped it and sent it off. The problem is we do not know where it's been sent to. And so in this foreclosure proceeding, we've uncovered numerous violations, and if we can get into that, I would be more than happy to answer those questions.
Yes, and we definitely will, Bill. My biggest contention at this point is whether or not that promissory note has discharged the obligation of the obligor. Would you or would you not agree to that?
I would agree to that. If there's any alteration to the note, it would discharge.
Okay, so then the plaintiff in this case has no financial obligation pursuant to the promissory note. Is that then correct?
If there's an alteration to a note, yes, that's correct.
Okay, so I turn your attention now to the deed of trust. Is the deed of trust in this matter much more than a simple contract under the law?
Well, the problem with this deed of trust is it was recorded several times, listing BAC Home Loan Servicing LP, FKA Countrywide Home Loan Servicing LP. The problem with what I've uncovered here is that the deed of trust has been recorded and substitutions have been recorded several times. They've all been recorded on the same date at the same time. Not even 1 second. I'm not even sure how it's even possible, But in this case, that's why they have a time, recording date, and timestamp on there. So I couldn't tell you, quite honestly, which one came first.
Okay, with the specific irregularities notwithstanding, how many aspects of fraud have you discovered have been committed by the defendant in this matter concerning the deed of trust?